This show is pre-recorded and furnished by Karl Gerber and Employment Lawyers Group. AM790 KABC.
Text and whatever. Just don't text and drive. Visit StopTextsStopWrecks.org. A message from the National Highway Traffic Safety Administration and the Ad Council.
Oh yeah, the lawyer's gonna represent you.
Talk Radio 790 KABC. This is the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, and you know what? I really am a real workplace lawyer, and you're going to know that tonight because this is a special episode for the coronavirus, and it's not going to be comedy. I'm sorry if that disappoints you, but I've been asked by a number of news stations to give a show about the employment laws and labor situations if the coronavirus begins to affect the California workplace. So that is what we're going to be talking about tonight. So this is a serious show. There are a lot of labor laws, as I said many times on KABC, and you're going to hear about some of them tonight with a particular emphasis on the coronavirus, which is a serious matter. So this will be a serious show. Sorry to disappoint you. You can go to the Karl Gerber with K channel on YouTube for all that great commentary that everyone thinks is the best social and societal commentary going on right now for the culture of the United States. So anyways, I really am licensed in California. All I do is practice employment law when I'm not doing this, and so I've been doing that since 1993. I'm also licensed in Massachusetts, Texas, and Washington, D.C., but I'm going to give you a focus on California because I think most of our listeners are in the Southern California area. So the virus now we know is called the COVID-19, and there are approximately 3 labor laws which are really important about leave rights if you are infected, but this is going to be about other issues also if there are infected people at work and about discrimination. So one of the laws that comes up is California sick pay, which is a fairly new law. There are not a lot of cases on it, and I think you really need to understand how that works. You also need to understand how the California Family Rights Act will work if somebody has the coronavirus and the difference between that and employment disability laws. So those are going to be 3 of the laws we talk about. We're also going to talk about business discrimination and some interesting issues like what if you are at a company and one of your employees is refusing to order a product from China or maybe Italy now because they think that it might be infected. Is that legal or is that illegal? Can you boycott businesses that are in other countries? So this will be a good episode for people that are in the workforce, for people that aren't in the workforce and are buying products, okay? And employers too are going to learn something from this. So the first issue which is going to come up with a lot of people is if there's a 14-day quarantine, I might have some symptom, I might test positive, and there's a minimum of a 14-day quarantine. We've also heard that there may be a need to test negative for the coronavirus 3 days in a row in order to get out of quarantine. So someone could be quarantined for a while with the coronavirus. They're going to be missing work. And there are people who could be sicker and are going to need more time to recover. So if that happens, what are their labor rights? The first thing is obviously the California sick leave law applies, but the California sick leave law does not provide that much paid sick leave. And if you have a 14-day quarantine, you're going to run out of it. You're going to run out of it very quickly because most employers only have to provide 3 or 5 days a year of that. So I don't think that law is going to go anywhere unless you're, I don't know. I just don't. I don't know how that law is going to apply to the coronavirus. I've heard people talking about how it is, and I don't think that's where it's at. The other thing is the California sick leave laws require generally if you actually go to a doctor. Now, with the coronavirus, that's not going to be an issue because we're all presuming that you're going and getting treatment. You need to call the CDC. You need to do what you have to do to get the right tests. So the real law that is going to come up with I'm missing work, I have what might be the coronavirus. I might not have it. I'm in self-quarantine. The big law that is going to help most employees is the Family Medical Leave Act. That's the federal version. And in California, it's called the CFRA, California Family Rights Act. That's part of the Fair Employment and Housing Act. It's Government Code Section 12945.2 if you want to look it up. But I tell people, if they're not lawyers, don't do that. You might get the text of a law, but you're not going to understand how it's applied, and you're going to be misinformed. You need to talk to a lawyer. You need to talk to a lawyer if you think you need to be out of work for a long time for this, or if you actually get fired for it. I am a wrongful termination lawyer. I can be reached at 877-525-0700 during normal business hours, 9 to 6:30 during the week. If you have been fired from your job, or you think that the California Family Rights Act may apply to you, maybe not even with the coronavirus, but about something else. So I can reach at 877-525-0700, 877-525-0700 for California employees who are fired because of various medical conditions. Now, the California Family Rights Act, which I would prefer you use opposed to the federal FMLA. Federal FMLA, you can't make a claim for emotional distress. And if someone is fired because they have a serious medical condition, which is the prerequisite for the act, they're going to have emotional distress. They're going to be distraught because they're sick. Maybe with the coronavirus, maybe with being quarantined because someone thinks they have it. They're going to be distressed. That's not the time to be fired. You're going to be missing work. You might be losing out on wages. And so if you are fired in those circumstances, you're going to want to make a claim for emotional injury most likely, and you can't do that under the federal law. The federal law has a longer statute of limitations, and it doesn't require what's called the right to sue letter. But I don't think that's going to be a problem if people are having employment problems in the next couple months and they actually get to an attorney in a timely manner. So there are requirements for the FMLA. Not everyone is an FMLA entitled employee. You have to have been at the company for 1 year, 1,250 hours worked. So people who are part-time to some extent may have coverage if they worked enough hours. The second requirement is there must be 50 employees within a 75-mile radius of where you worked. Not enough employees, law doesn't apply. So got to keep that in mind. Third requirement is you must suffer from a serious medical condition. Coronavirus unquestionably is a serious medical condition. The issues that come up with is it a serious medical condition is, did the employee actually go to a doctor? Well, with the coronavirus, there will be medical treatment. And doctors include all licensed healthcare professionals. And so if you go to a nurse to be tested, that counts. So I just don't think there's any issue that the coronavirus qualifies as a serious medical condition under the California Family Rights Act leave and the FMLA. So you will have a right to miss work for up to 12 weeks under those acts. Not longer than that, just 12 weeks. And that's within a 1-year period of time. So if you took other leave before for CFRA, FMLA, well, that time counts too. So at this point, you have to say, is there enough time to be out? You cannot be fired if you're on CFRA leave or FMLA. The employer must know of the existence of your condition. If they don't know, you don't fill out the right forms, it's not going to work. And I would encourage you to retain counsel as quickly as possible if you are fired because of a serious medical condition, including the coronavirus or something else. Don't let time go by. You've got to sue and get your right to sue letter in California within 1 year. Federal, longer, but again, no emotional distress. Please call me at 877-525-0700 if you were fired due to a serious medical condition or a disability, which also has coverage under FEHA. I'm at 877-525-0700 during normal business hours, Monday through Friday, 9 to 6:30 p.m. That's 877-525-0700. I have done many FMLA cases, trials, arbitrations on it. I've won them. I only lost one of them in my career. So I can be reached. I am Karl Gerber. This is the Karl Gerber Workplace Lawyer Show. We'll be back in just one moment to continue our discussion about how the coronavirus affects employees and leave laws.
Since 1993, the Employment Lawyers Group has been a consistent force in fighting for the rights of California employees. They've represented thousands of employees in cases in which they've lost their jobs, been sexually harassed, discriminated against at work, or owed wages individually or as a group, such as a class action. The Employment Lawyers Group has maintained a high win rate and a serious record before the California courts. Please call 877-525-0700 for an experienced work lawyer. That's 877-525-0700. They have call takers standing by. Online, research the firm at worklawyerca.com. They have offices throughout Southern California. If you hire the Employment Lawyers Group, your legal problem becomes theirs to solve.
I was 9 when I lost my leg to bone cancer. I had a 50% chance to live. After chemotherapy treatments at my children's hospital and the amputation, I had beaten the odds. But would I ever be as active as I once was? Fast forward 20 years, I've competed in the Paralympics and now play on the U.S. amputee soccer team. Help kids live their dreams just like me. Put your money where the miracles are. Give to your Children's Miracle Network Hospital.
Do you have concerns about mild memory loss related to aging? And have you thought about taking a supplement to improve your memory, but would like to hear from a pharmacist first? Now there is good news. Prevagen is the #1 pharmacist-recommended memory support brand, so you can safely take care of yourself with confidence. Prevagen, healthier brain, better life. 2019 Pharmacy Times survey. Statements have not been evaluated by the FDA. This product is not intended to treat, cure, or prevent any disease.
Bass Pro Shops and Cabela's is your ammo headquarters, and we will not be undersold. We've got the area's largest selection at the very best everyday prices, and you'll save even more when you buy in bulk. Come in now and load up on the best deals on handgun, rifle, rimfire, and shot shell ammo. When you think ammo, think Bass Pro Shops and Cabela's. Shop in one of our hundreds of stores across the country or online at basspro.com and cabela's.com. Your adventure starts here.
1 in 3 adults has prediabetes. 1 in 3. That means it could be you, your football buddy, your football buddy, or you, your best man, your worst man, you, your dog walker, your cat jogger. While 1 in 3 adults has prediabetes, with early diagnosis, prediabetes can be reversed. Take the risk test at doihaveprediabetes.org. Brought to you by the Ad Council and its Prediabetes Awareness Partners.
In the CDC recommended 20 seconds it takes to wash your hands, you can learn a lot. Fast talking and right. The Ben Shapiro Show. Afternoons 3 to 6 on AM790 KABC.
Oh yeah, the lawyer's gonna represent you.
Talk Radio 790 KABC. This is Karl Gerber, and this is the Karl Gerber Workplace Lawyer Show. This is a special edition of the program to talk about the coronavirus and how it may affect the workplace and what rights employees may have. This is not a comedy show. I'm sorry, you'll have to wait for the next installment next week. You can go to the Karl Gerber with a K channel to hear what we have done comedically, including about the coronavirus. But at this point, it is no longer a joke. And so I have been asked by many stations around Southern California, really all TV, to give an explanation of how the labor laws in California might work with the coronavirus. That's what I'm here to do tonight on KABC. But I also want to talk about how there are people just in business and how you can't be discriminating against companies that may have origins in places where the coronavirus is more prolific, like China. Before we broke, we were talking about the leave laws that are going to work for employees that may be affected or employees who may think they are infected with the coronavirus. I don't think that paid sick time is going to go far enough for most people with the problem because of the quarantine period, and also because there are some people that may develop sickness and need to be out of work more than just a 14-day quarantine period. Presumably that quarantine period begins once they test negative. So the law that seems most applicable is the California Family Rights Leave Act and the FMLA. The problem with that is you have to have actually worked at the company for a year, and you have to have put in 1,250 hours. So if you're 20 hours a week, you're not going to get protection. If it's a smaller employer, like my office, for instance, we don't have 50 employees in a 75-mile radius. There is no FMLA coverage. So that is a problem, okay? It's going to be a problem for employees who work at smaller employers in getting coverage to be out. The next issue is going to be, well, is this somehow a disability? I don't think it is, because a disability under California law and federal law, which is much harder, requires there to be an ongoing medical history for a very long period of time, and that is not what we're seeing with the coronavirus. We're seeing people who can be sick. It may be a month. I'm not even hearing that there are people with 2-month periods where they're incapacitated and then going through quarantine. So the length of time that they are going to suffer is not long enough to be a disability. Disabilities also have permanent effects if it's not just a very long history of medical treatment, maybe a year, maybe 2 years. I actually won a case like that as a disability where it went on for a year and a half or two, but the lady got better. But with the coronavirus, I don't think the employee will suffer long enough for a disability. And so we come to a pretty dicey situation for employees in California if they come down with this. They're not going to have job protection. I don't know if there's going to be some emergency laws that get passed if this becomes a real problem in California. Right now, we just don't know, and we're hoping, obviously, that this is not going to have a major effect in California. But I think people want to know what their rights are and think about these things and makes them feel better, and so that's one of the things that I'm trying to do tonight. But I'm sorry to be the bearer of bad news. I don't think that there's going to be a lot of protection for employees who have symptoms or think that they should be quarantined. They're not going to have a lot of protections at work. Now, I speak for employees at private employers. I'm not speaking for government employees and union employees. They have different rights than the normal statutory rights for family medical leave, California Family Rights Act leave, which is the same thing and really is the leave that I feel is most applicable. So that's something that they'd have to consult their union handbook on or figure out what the rights are of the agency if they are a public employee. The other legal issue for the workplace with the coronavirus that screams out to me is workers' comp. If somebody was working in one of those nursing homes and a number of people came down with it, it would be a work-related injury. Work-related injuries do include diseases that employees pick up at work. Right now, I have a client who picked up hepatitis working in a hospital, and she wasn't even a nurse. It was just something that was rampant in the hospital. So that is a work-related injury. There is a workers' comp recovery for that. The fear that you may come down with it because they're other exposed employees may also be something that employees can either sue for, maybe in tort, most likely in the workers' comp system. I'd like you to call me if you're having those fears. I can be reached at 877-525-0700 between 9 a.m. and 6:30 p.m. during the week. 877-525-0700 if you're experiencing fear or anxiety because you may have been exposed to the coronavirus at work. 877-525-0700. 0700. I'm licensed in California. If you think you've come in contact with the coronavirus at work, or you have a fear that you were exposed in some way and perhaps your employer was negligent in taking the proper precautions. I'm also licensed in Texas, Washington, D.C., and Massachusetts. I really am a real workplace lawyer. I know many of you on this station know me as the comedy lawyer because we have a show that comes on every week called the Karl Gerber Workplace Lawyer Show, and we're on at the hot spots on the weekend on this station. And that is a funny show in which we talk about employment issues, but it's really out there. It's the craziest, most outlandish sketch comedy show on any commercial radio station anywhere. I'd encourage you to go to the Karl Gerber with a K channel on YouTube and listen, or workplacelawyer, all one word.org, workplacelawyer, all one word.org for episodes of that. But tonight, Karl Gerber is being serious because the coronavirus has become very serious to a lot of people in California and elsewhere, and it's raised issues about what rights employees have. Now, I have had an incident in the office where we have an employee who likes to buy things and have them shipped to the office. And he's been buying a lot of product from China. I think there's some kind of seeds or something for gardening, but it has made some of my staff concerned that these items are coming in from China where they think the coronavirus is. Now, I don't know if that's a reasonable or unreasonable fear. That's something that really a public health expert or someone in the medical profession would be better able to answer. But what does an employer do if it's as innocuous as that? You have an employee who is receiving product from somewhere where it's known there is the coronavirus. I mean, now it could be Italy. Italy is big for some plumbing parts I've bought. I also do construction, and we bought some parts from Italy for a shower, for faucets, some high-end stuff. And if that gets delivered over to someone's office, are they thinking, and maybe unreasonably, that the coronavirus could be on the package? What obligation does the employer have to stop their employees from having personal shippings coming to the office from these places? Is that simply discrimination? Is that wrong? Or is it something that employers need to take seriously? Because if employers are exposing their employees to things that are getting them very anxious and very concerned about, that can actually be a workers' comp case, a work stress case. And I think employers need to be mindful of that, and they need to be very mindful that they should not be offending people from certain ethnic groups if they are naturally getting product from Italy. I mean, if this was a restaurant and we're trying to buy Italian olives, which, by the way, I've read most of them are not Italian olives, and the mob has done all kinds of things with that, but that's another story for another day. But, what if the restaurant staff says, I don't want to work with these olives because they're coming from Italy, and I think everyone's got the coronavirus there? What does the employer have to do? And can an employee refuse to work with a product that came from a country that has the coronavirus? I want you to think about that. I also want you to think about whether maybe it's best that some employer actually consult with someone in public health that could answer that question, whether the coronavirus could really be on a plumbing part that was in shipping for 6 days, and whether it's appropriate just to dispel those fears with your employees. All right, so I am a real workplace lawyer. I want you to call me at the office if you have a real case for being fired for a medical condition or a work injury. 877 excuse me, 877-525-0700 between 9 and 6:30 during the week. I can be reached at 877-525-0700 if you feel that your employer has unnecessarily exposed you to stress or anxiety. 877-525-0700 if you have issues at work and have been fired from your job for reasons that you believe are illegal. Remember, it's got to be illegal or it's got to be based upon a protected characteristic why you get fired, like your age or a medical condition. All right, we'll be back in a minute on the Karl Gerber Workplace Lawyer Show. We're going to talk about general discrimination with the coronavirus when we come back. This is Talk Radio 790 KABC. Talk Radio 790 KBC. This is the Karl Gerber Workplace Lawyer Show. I am Karl Gerber. I am a real workplace lawyer licensed in 4 states. You may know me as the lawyer with the sketch comedy show on this station, but tonight, well, this is a special broadcast. This is a serious broadcast about the coronavirus, how it may affect employee rights, employers too, what they may have to do, and just general business discrimination. So if you want to hear some comedy, go to the Karl Gerber with K channel on YouTube. Tune in next week at the regular time of the show. You'll hear it then, but this is serious. And so we've talked about the leave rights employees may have. We've decided that really the one that applies is the Family Medical Leave Act or the California Family Rights Act. And that requires 50 employees in the company, a 75-mile radius, 1 year of employment at least 1,250 hours. It also requires that you have a serious medical condition, which I don't think there's any dispute that the coronavirus is that. Now, there are going to be cases where people want to self-quarantine, and they may have absolutely nothing wrong with them. And the question is, if you self-quarantine, do you really have a serious medical condition? I would hope that employers give some latitude and are a little bit liberal on the Family Medical Leave Act under these circumstances, because the public policy that we want to foster in this country is for people to self-quarantine and not to spread the virus. And so they shouldn't be penalized and fired from their job. If someone is on family medical leave, CFRA in California, same thing, they have a right to reinstatement from their job. And they have a right to be reinstated at a comparable position. And it doesn't have to actually be the exact same job, and it has to be comparable pay. So that's going to be the other issue that I see. Let's just say someone does go out on self-quarantine, or someone goes out, they actually had, hopefully not a very major case of the coronavirus. They got better, and I don't know, 2 weeks, got tested those 3 times every day, didn't have it. They're ready to go back to work in 18, 19 days. Awful experience, but health-wise, they're okay. They want to go back to work. They haven't been working for a couple weeks. Maybe they've got some kind of pay through the EDD, that's the unemployment department here in California. Maybe they haven't. Maybe they don't want it. But they want to go back to work, and their workers find out why they were out. Normally, employers cannot disclose an employee's medical condition. That would be an invasion of privacy. If somebody goes out for something, even cancer, you can't go and tell everyone, oh, well, so-and-so went out for cancer. Now, with the coronavirus, I wonder, because there is a public health need for the county health officer and other people involved in the stopping of transmittable diseases, knowing who has it and who they may have come in contact with. So I'm not sure how that's going to work, whether this is private. I do suspect that there's going to be some knowledge of the workforce that so-and-so went out for actually having the coronavirus or being suspected of having it, maybe being a very responsible citizen and doing the self-quarantine for 14 days. Now, when that person wants to come back to work, I'm concerned that they may be discriminated against. And the question becomes, what right do they have if they're being discriminated against. Now, if they were on the FMLA/CFRA leave, same thing, the one with the 50 employees, 1 year of employment, all that. If they were on that, they have to be reinstated. Now, there is an exception, which I get on these trials and cases, where the employer says it's an undue burden to have this person back. And if the workforce is all going to walk out because they think the person had the coronavirus, what are we going to do? That could be an undue burden. It's a horrible, horrible situation for everyone involved, but I really can see that happening. I really can. And I've heard, and I'm not going to say I have statistical evidence on this, but I've heard that there's been a lot of discrimination of Chinese businesses. I've heard that it's as much as 60% of their revenues are down since the coronavirus. And these are people that have nothing to do with the coronavirus. They haven't traveled out of the country. They don't have it, but there's just this fear at this point that if you're from so-and-so country, you might have it. So I am concerned what's going to happen if someone goes out of work and comes back, doesn't have any symptoms anymore, and then they're not allowed to work. And what if they weren't on family medical leave? Because I can make a retaliation case there. I can make a failure to reinstatement case. I'll do it. If you want me to do that on something other than coronavirus, you can call me at 877-525-0700, normal business hours, 877-525-0700, 9 a.m. to 6:30 p.m. during the week. I really am a workplace lawyer. I don't just play one on the radio. 877-525-0700 for Karl Gerber, the workplace lawyer. So that is one of my concerns, is the whole reinstatement issue and whether people don't get reinstated, or if there are claims that there's so many people that went out with these symptoms that the company has to shut down. They're not going to do production this season. You know, if we're in agriculture, there certainly are certain seasons for doing things. There's seasons for doing things in fashion. Every business has seasons in which they do something. And if they don't do it, they might not be selling their product at market. We had a show about selling product at market not long ago, and that was comedy. And if you listen to the Karl Gerber Workplace Lawyer Show regularly, I think you might know what I'm talking about. That involved Dr. D, and that was the banned episode on YouTube where we got a strike because I thought our show, which is on the radio and is all sound, they thought it was visual images of sex and pornography. Well, I don't think so. You know, if we're the best sketch, outlandish comedy in the United States right now, Script It Weekly, and YouTube doesn't like that, well, I think that creates a little bit of an issue now, doesn't it? So if you want to hear that kind of stuff, you can go to the Karl Gerber with a K channel on YouTube. But tonight, we're being serious. We're talking about the coronavirus. We're talking about reinstatement for people that went out on a leave because of it. We've also talked about how it may constitute a work injury if you contracted it at work. We've talked about how the fear that you may contract it at work because your employer was negligent in not quarantining people. We've talked about that. We have talked about whether the employer starts removing people for fears of the coronavirus, so I think we should do that. Now, the employer, obviously, if they just start removing people of certain ethnicities, well, that's going to be a violation of the law if there's no evidence that those people have any symptoms or exposure to the coronavirus. If people who are Chinese or Italian or Iranian are removed because the feeling is, well, hey, you know, even if they haven't been to those countries recently, maybe they're hanging out at, you know, little this or little that, and they're going to come in contact. That is just old-fashioned national origin, maybe race discrimination, and that's something I definitely would sue for under the Fair Employment and Housing Act. And I hope to God that doesn't happen, but we have heard that there has been some unnecessary discrimination from people of different ethnic groups, different makeups, because they come from countries that are associated with that. We have not talked about business discrimination. Is it appropriate for a big business, and I'm not saying they're doing this, but let's just say for some reason, Walmart, they're a big business, and they actually have a great internet presence. They're one of these retailers that figure out how to do it on the internet, and they're doing a great job. And a lot of their product comes from China. But what if somehow they decided we're going to stop buying Chinese products because we think somehow we could be infected? Now, is that legal? Is it legal to do that? And what if one of the employees said, I don't want to do business with Chinese product right now. I feel unsafe with it. And what if the employer says, well, that's discrimination and you can't do that and you have to do it? Does that create a legal case? There are a lot of legal issues that are going to come out of this virus if it becomes, well, they say it's a pandemic, but if it becomes a major issue in the workforce in California, I'm hoping that employers figure out how to do this right. I'm hoping that we don't have problems everywhere we can with defamation and employers claiming people have a loathsome disease when they don't, because that actually is slander per se if you accuse someone of having a loathsome disease, and I think this would qualify as that. It used to be sexually transmitted diseases. Well, this is not that, but it is a loathsome disease, and so that could create defamation issues too. So I think these issues are gonna just kind of come to me because I'm usually at the forefront of whatever employment issue happens in California. I can be one of the first people to bring the case, the first person to brief it. The legal issues I have in my cases usually that come up, no one's had them before. You want to give me a call about an employment case, I can be reached at 877-525 during normal business hours. That is 877-525-0700. I'm licensed in 4 states. California is my first state. I go back to 1993. I was the first employment lawyer in the phone book in the San Fernando Valley in Los Angeles back then. I can be reached at 877-525-0700, employment discrimination, work injuries, wrongful termination, fired for medical conditions, all that kind of stuff. I am Karl Gerber. This is the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC. We'll be back in just one moment.
Since 1993, the Employment Lawyers Group has been a consistent force in fighting for the rights of California employees. They've represented thousands of employees in cases in which they've lost their jobs, been sexually harassed, discriminated against at work, or owed wages individually or as a group such as a class action. The Employment Lawyers Group has maintained a high win rate and a serious record before the California courts. Please call 877-525-0700 for an experienced work lawyer. That's 877-525-0700. They have call takers standing by. Online, research the firm at worklawyerca.com. They have offices throughout Southern California. If you hire the Employment Lawyers Group, your legal problem becomes theirs to solve.
Oh yeah, the lawyer's gonna represent
Talk
you.
Radio 790 KABC. This is the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, and I'm a real workplace lawyer. And tonight, we've had a really serious show talking about the coronavirus and how it may affect the workplace. And someone just wandered into this room here. And, what's your name? You're looking at me and you're pointing. What's your name?
Anne.
Could you spell that?
A-N-N?
That's a weird spelling. Who do you work for?
I work for you.
You do?
Karl, yes, I work for you.
Oh, this is so embarrassing. I've known this woman since like 2006, and she came in here and I didn't recognize her.
It's the new haircut. Come on.
No, there's no new haircut. I can't explain it. So Anne is actually, I'm not making this up, she's also a lawyer, and we've been talking about the coronavirus, and my question is privacy, because I think that employers may have to actually tell their employees that somebody is coming off a quarantine, maybe a self-quarantine. Now, Do you think this might be an exception to the usual privacy laws, Anne?
I think it should be, because everyone else's health is in the line here, and people need to know who is home for this kind of an illness, because if they're not in quarantine enough days, then they can infect everyone else in the office. It's an unfortunate situation. I don't know if we had something like this before, but we have to handle it differently.
Could that, though, discourage employees from self-quarantining? Maybe they don't even have it. That would be my concern, is they're afraid that now everyone in the workforce is going to know that they thought they were exposed, or maybe they were.
Yes, it will, but people have to step back and look at this. If your immune system is not as great, maybe you have diabetes, you could die from this illness. So that's more important than someone's privacy, or someone being afraid to tell everyone that they may have the virus. They may have to stay home. Maybe they don't have it, they'll get tested, but they have to stay home. It's the right thing to do.
Which means that we really need to take social, what do you call it? I mean, social responsibility, really, in a situation like this, because it's not just about you, it's about everyone else you work with. I hope that we don't have a lot of people that come down with symptoms, or people that are self-quarantining in Los Angeles County. If that is the case, though, it seems that perhaps the identity of these employees who are doing that is less secret, because, you know, how many nurses are there at X nursing home, or how many dietitians or whatever are there at the nursing home where they end up having the outbreak? So I'm not really sure that privacy is going to be protected in this situation with the coronavirus.
I think privacy will have to take a step back, because right now, whoever is infected is in the newspapers with their names, most of the people, and people that are dead, you can find out who they are. Why would employment create a second curtain of privacy here when people could die from this? I think it's more of a responsibility. It's much more serious than just protecting someone's privacy.
We do deal with privacy in our cases. It's in the California Constitution, Article 1, Section 1. It comes up in employment cases, and the issue is really a balancing test, and the question is, did the interests in privacy get outweighed by the importance of what has to be disclosed? And here, it is very important for the workers to know that there was somebody in the workforce that they may have come in contact with. But now we're hearing that, maybe 6 feet contact with someone is enough to transmit it. And so, I don't know. I mean, if you're working at a job, there's a lot of people you come within 6 feet of. And so maybe it's not as necessary to bring up everyone's name that could have had it. But these are issues that are going to come up.
Well, you don't have to bring up someone's name, but someone is at home for 14 days. Everyone knows that they're self-quarantining themselves.
And we see in a lot of cases a lot of speculation. A lot of the new client calls we get, the cases we can't take, it's because someone is just speculating that they must have been fired for some reason, or it must have been their race that got them fired. And I'm afraid that we are just going to have all kinds of issues that are very speculative. Employees are speculating that someone out for 2 weeks is out because they're self-quarantining. And in fact, the employee is really out because they're having prostate surgery or who knows what. So I think we need to be careful not to be just speculating at work.
And also, if it's prostate surgery, medical records or notes given to the employer will clarify that.
But the workforce doesn't know that, and they think, well, this person's out for all this time, and it must be because of the coronavirus. I've seen a lot of people with cancer not wanting to be specific with their employers about the fact they have cancer, and I think that's a big mistake, because there's a lot of rights for people who have cancer and need to miss work. And if the what the employer doesn't know, they're not liable for. So the employer does need to know the nature of the medical condition. And if someone is being very cagey about this and they don't want to disclose that they have the coronavirus, that's going to be another issue, because the leave laws are not just going to pop into effect if the employer has absolutely no idea what's wrong with the person. But with the Family Medical Leave Act, we get a lot of cases where there's a vague doctor's note that's initially filled out, and the question is that enough to start triggering the Family Medical Leave Act? Most of these employers at that point send back a form, usually a Department of Labor form, where the doctor has to certify it and has to be more specific. But in that case, Anne, do they have to put down the nature of the diagnosis? I think they do.
I think it's to the benefit of the employee if the illness is placed in paperwork and given to the employer. That's the biggest protection you can have. As you said, cancer has a lot of protections.
We've had a lot of cases where the duration of the pregnancy leave needs to be on the form according to the employer, and exactly what the restrictions are. So can that be done without saying this person is pregnant? And maybe doesn't need to say pregnancy if it says the person has to have a 10-pound lifting restriction for 4 months. But the same problem is going to come up with this, that employers are going to need enough information to get the Leave Act to work if they can. And these cases are going to develop, and I know that we're going to get calls about them, and I hope we don't. I hope that employers are good. I hope they offer more protection than they need to. And I also hope that really this isn't that big of a deal and it passes over and we don't have a pandemic in Los Angeles County or California. But if you do end up having a problem, you've been fired because of a medical condition, I do want you to call us during normal business hours, 9 to 6:30 at 877-525-0700. It might be because you were fired because of cancer. That's something that I will jump on the phone and get involved in. 877-525-0700 if you were fired due to a medical condition that is most likely protected. You're wondering if it's the Family Medical Leave Act that covers you, or it might be disability law or something else. Well, that's what we do here. 877-525-0700 between 9 and 6:30 during the week. 877-525-0700. I would encourage you to go to our legal websites if you have questions and you just want to do some research. One is called worklawyerca.com. That's a good one just to find out your rights. But if you want to catch up on old episodes of the show, you should go to the Karl Gerber with a K channel on YouTube. If you would rather hear comedy on this, well, that's where you go. And you can go and listen to the old episodes because all of them are on there. And if you go to workplacelawyer.org, not a legal site, it's just a site about the show, you can find out all of the episodes that ever were on there. There's this here, episode 101. Can you believe we've done 101 episodes on KABC so far? That's a lot of episodes. That's more than the Brady Bunch ever had. That's more than a lot of shows ever had. It's a lot of content. It's legal content buried in the best sketch, outlandish comedy, really anywhere. It's scripted on a weekly basis. It's very now. We have professors, people involved in cultural studies saying that the show represents the best description of the American culture right now. So I think you should check that out. But tonight has been a very serious show because the coronavirus now is coming to California. There are many questions that employees have, employers have, and we've talked about a lot of them. You can go back and listen to this show, or again, call our office at 877-525-0700 if you need a lawyer. Thank you for listening. I hope there aren't any problems at work for you this week. But if there are, I think you know where to call. This is the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC. Thanks for listening, and come back our usual time Saturday at 7 p.m. on this station.
This show is pre-recorded and furnished by Karl Gerber and Employment Lawyers Group.